Hello and good, well, morning still. I was about to say afternoon, but no, it is still a wonderful Thursday morning. Hello, everybody, and welcome to this panel on the collateral damages of enforcement. We're going to be talking in this panel about the Loi Avia, the French law. We're talking about the Netzwerkdurchsetzungsgesetz, long word, so it must be German, the Network Enforcement Act, and also the Kommunikationsplattformgesetz. The Austrians like long words as well. And then, of course, last but not least, the Digital Services Act that was introduced in draft by the European Commission in December, and that will certainly keep us interested and busy in the next couple of years at least. So how do we go about this? I have the pleasure of having 4 plus 1, no, 3 plus 1, counting, 3 plus 1 fabulous friends and speakers here on this panel. I will. Let's hope the mystery guest will disappear. Will appear as well in due time. Let's start our little journey through the digital services jungle and through Europe. Let's start this little journey in France, or rather in Switzerland, but I'll get back to that in a minute. Let me introduce Suzanne Vergnolle from the Université Paris 2 Panthéon-Assas. How is my French?
It's pretty great. Assas, okay. But yes, it's
Assas. Okay. One. Yeah. Okay. You're working here. You're teaching here. We've just been talking about our experiences in online classes when you're a teacher, and you're focused on the effectiveness of protecting individual rights by data protection law. So that all things privacy, data protection, open data, and international criminal cooperation is covered by what you're working on. And you will now make us familiar, Suzanne. Well, I was saying I should say a word about Switzerland because you are in.
Yes. I'm in Lausanne. So
in Lausanne. Okay, great. Wonderful. So you can go skiing. But we're not going to talk about Swiss law now, but we're going to talk about the Loi Avia. That's a difficult one for me. And you're going to explain to us what this law is all about, the French version of the DSA, if you could call it, and you're going to tell us what it's all about and what issues are that are discussed controversially. So
thank you.
Go ahead, please.
Thank you, Niko. Thank you for this introduction and for organizing this panel. I would like to start by emphasizing the importance of social media, websites, and more broadly, the internet for advancing free speech, art, and culture. Thanks to the internet, we are now more informed and we can express ourselves more freely than ever before. That being said, there are risks linked to certain type of that can be found on the internet. I think notably of content that promotes hate, crime, or terrorism. The difficult question here is how to regulate speech online. And the decentralized and international nature of the internet make it difficult for regulators to implement rules. It's even more difficult when we're talking about transborder enforcement. In the early 2000s, both Europe and the United States enacted rules regarding unlawful content online. These rules provide that intermediary service providers are not liable for illegal content posted by their users, as long as they swiftly remove it once someone flags it as being manifestly illegal. In the US, we all know this rule is set in Section 230 of the Communications Decency Act, and in Europe, it is the Article 14 of the E-commerce Directive. But, the 2000s were another time. Since then, the internet has swayed elections through the spread of fake news, facilitated cyberbullying, and has dramatically increased the distribution of child sexual abuse material. So for the past few years, discussions about how to address these problems have emerged in the public debate. The big question here is not what can be done, but how can it be done? We all agree that this content should not be available online, but how can we reduce its spread? So in France, in 2019, French Member of Parliament Laetitia Avia sponsored a bill aimed at fighting various forms of online hate speech, terror content, and child sexual abuse material. Again, if we all agree on the key goals of such a law, its implementation was rightfully challenged. The two key provisions of the law relate to more stringent rules for big platforms and search engines. The first one relates to the obligation of platforms to take down terrorist or child sexual abuse materials within 1 hour. After receiving a request from an ad hoc administrative authority. Yes, the Parliament decided it was appropriate to entrust an administrative authority with the power to declare what should be taken out of the internet by platforms. The second important provision relates to taking down content at a user's request. So here, when a user flags content as being manifestly unlawful or as being pornographic or hateful material, the platform has 24 hours to verify its lawfulness and eventually take the content down. If the platform did not comply with these two takedown requirements, each violation would be severely penalized by a high fine. During its adoption, the bill was largely criticized, and for good reasons. Asking platforms to do content moderation under such a short time notice could harm free expression online. Given the liability created by the law, platforms would have incentives to take down content at the border of lawfulness. With this system, will lead to an overly broad removal of content and less free expression online. Also, allowing an administrative authority to decide which content should be or should not be accessible can be really problematic, since the administrative authority doesn't have the same guarantees of independence and neutrality that apply to the judiciary. Despite criticism, the law was enacted by the French Parliament on May 13, 2020. However, in France, when a law is enacted and before entering into force, members of Parliament can refer it to the Constitutional Council, so the institution can review its constitutionality. That's exactly what happened with the Loi Avia. So on June 18, 2020, the Constitutional Council declared the overwhelming majority of the Loi Avia's provisions unconstitutional. So on the slide, you can see in red the extent to which the ruling invalidated the law. So you can see all the red things are actually the things that were declared unconstitutional by the Constitutional Council. So the overwhelming majority. Dismiss the slides. So all the provisions regarding the takedown mechanisms were declared unconstitutional. The only few provisions remaining relate notably to the ad hoc authority that was created by the law. So the French now have yet another administrative authority that can that has no reason to exist, since most of its mission were considered unconstitutional. Many activists were delighted and relieved with the constitutional decision. But, in France, we have a saying, and it says, chase it by the door, and it comes right back in through the window. Unfortunately, that's exactly what's happening with the problematic provisions of the Loi Avia. A few days ago, the French government amended the bill on Republican principles to include content moderation obligations for large online platforms. The amendment is similar to the Commission proposals for the DSA. We are all closely looking at this discussion to make sure the window is actually sealed. Thank you, Nico, and I'm really looking forward to discuss more about the DSA and the problematic dispositions.
Thank you very much, Suzanne. Just one quick question, Suzanne. The constitutional law decided the law was on everything you marked red was unconstitutional because of freedom of speech, or what exactly was?
So there were problems regarding freedom of expressions and concern that the time frame of content moderation was too narrow to allow a proper review of the content and to make sure that there was not an overly broad censored of the content. That's one. And the second thing was related to the ad hoc authority, and the Constitutional Council considered that giving the power to such an administrative authority to ask platforms to take down content would be very dangerous for free speech and for freedom in general, because it's not an independent authority. It's not a judge. It's not a magistrate looking at the facts and having a ruling. It's only an administrative related to the government and financed by the government to look at this content. So these were the main criticism by the Constitutional Council.
Thank you, Suzanne. Very, very interesting, and certainly a lesson or two that may be learned for the DSA from that. May I now travel from Lausanne to Arnd? Hello, Arnd. An IT law companion for much more than a decade, if I may remark that. You have been with Google all your life, and at least your professional life, and you are now the legal director for Germany, Austria, and Switzerland, the Nordic countries, Belgium, the Netherlands, Luxembourg, and also the European Union. So that is a lot to do for you, a lot of work on your shoulders. The one question that I'm not going to ask you is why the German equivalent to the Loi Avia, the Netzwerkdurchsetzungsgesetz, is on the one hand considered unconstitutional by many scholars, and on the other hand has not been contested at the German Constitutional Court. So assuming it is unconstitutional, we will possibly never find out, because our Federal Constitutional Court will not, as all the deadlines have expired, will not have a chance to look into the constitutionality. That is the one question that I will not ask you, Arnd, but I will ask you to explain the non-German parts of the audience what the Netzwerkdurchsetzungsgesetz is all about.
Okay, thank you very much, Nico, and hello everyone. Thanks for the kind introduction. And I don't know if the Constitutional Court in Germany will not review the NetzDG in the future. Who knows? Maybe it does. So let me briefly summarize the basics of the law for those who are not familiar with this law called Netzwerkdurchsetzungsgesetz, which is kind of a misleading name, network enforcement law, because it is actually not just enforcing the law, but it is a law providing very strict obligations by itself. And then maybe a few highlights about very recent developments in Germany around the NetzDG. So unlike the French proposal, the German law is already effective. And after a very intense academic debate, Niko was referring to, the German parliament has adopted already in September 2017. And it's applicable since 2018. So pretty much 3 years by now. So we've collected a lot of experience. The intention of the law was exactly to request social media providers to remove illegal third-party content very fast from the platform and to hold these providers accountable for any sort of non-compliance. The political approach was also to give complainants more rights and to achieve more visibility into the removal process. So just to highlight a few interesting provisions here from the Netzwerkdurchsetzungsgesetz. The scope that's important to understand is limited to social networks, in particular bigger social networks defined as those with more than 2 million domestic users in Germany. So it does not cover all intermediaries and it does not cover smaller networks. Then the law requests the removal of content. That's different to other proposals in other markets where harmful content is also in the range, but the German law concentrates on illegal content alone and refers to the German criminal code where the illegal content is defined. So hate speech, violence, child sexual abuse material, etc. The law requires us, the providers, to apply very strict turnaround times for these content removals. In cases where a layman would easily understand that content might be illegal, the content needs to be removed within 24 hours. In all other cases, within 7 days. Then we're asked to provide many transparency obligations. We need to publish reports about the compliance management every 6 months. And it requires us to inform every complainant about the progress of the complaint and every author of affected content about the removal. Then another interesting aspect is that that the cooperation with law enforcement bodies is made very clear. So here the social networks are required to store removed content for 10 weeks for any subsequent data disclosure request from police officers or other law enforcement bodies. And then last but not least, the law introduced regulatory fines up to 15 million euros for not providing an effective complaint mechanism and transparency. Extremely important to recognize here is that only structural deficits are penalized. So it's not the individual non-removal of content. It's just if the provider has set up the wrong structures to comply with that. That's the law as it stands right now. But this is already under review by the German government, and the government has actually introduced another draft act, which is called an Act to Combat Right-Wing Extremism and Hate Crime. And with this law, the NetzDG will be changed. This law plans to introduce a very extremely far-reaching and privacy-sensitive obligation requiring social networks to report illegal content proactively to the Bundeskriminalamt, which is the federal criminal police office. And the idea is that providers are obliged to proactively disclose mass data. And this is organized in such a way that we need to report about the content that we have removed or blocked. Wherever there's a concrete evidence that at least one of a list of specified offenses is fulfilled, we need to do that immediately after the removal of the content. And with the content, we need to provide information about the uploader, which is upload data, IP addresses, port numbers, etc. And that happens through an electronic interface that's provided by the police. So that's the idea. This law was put through the parliament, was signed because of constitutional concerns. So here, connection to France, again, like very heavy constitutional concerns. And now another law was launched with the attempt to fix these constitutional issues, pretty much like in France. And this repair law is actually supposed to be discussed in the German parliament just today. And then last but not least, the list is not over. There's another law reforming the NetzDG, which should give broader transparency obligation. Also introduces an extensive appeal process for complainants and uploaders. That law was just agreed by the Parliament in a draft version and was notified to the European Commission this week. And it will be very interesting to see how the European Commission thinks about this law and eventually expresses concern about this reform of the NetzDG. So I hope that gives you a good understanding of where we are in Germany right now.
Thank you, Arnd, for this overview. From your experience at Google, I mean, it's not a secret that Google was not enthusiastic law when it was introduced in 2017. What would you say? What has Google's experience been with the law? Has it been have the difficulties that you anticipated, have they come true, or how have the last 2 or 3 years of living with the NetzDG been like?
Yeah, it's a good question. I would say we tried to be good citizens and we implemented the law despite the many concerns expressed by academics and many others. So the challenges for us are like very obvious, right? It's now very easy for users to file complaints, and social media providers like YouTube now need to react very fast. And if we don't, then we face heavy fines, right? And the administrative burden that comes with the law is extremely high. So it's very labor intense, it's very expensive, but these are probably concerns that do not interest too many people out there. And I think it is more important to highlight the concerns that not providers have with the law, but that we as a democratic society should have. And I only mentioned 3 points, and they are really important in my mind. So one is this concept that private companies now have to decide in millions of cases what is illegal and what is not. So this was not our choice as a company. This was the decision by the lawmaker. So conceptually, I think this remains to be a problem when we think about what happened in the US with Trump. Because at the end of the day, the question what is illegal or not is for a judge to decide, not for companies. But what should we do? We are in that position, required to do exactly that. But that's a systemic challenge. And then the second point is overblocking is a reality. The NetzDG reporting button is very prominent and leads to many complaints. That's by design, that's intentional. I give you a number. Last year alone, we received 600,000 NetzDG complaints in Germany alone for YouTube. And most of them are absolutely invalid. They are not justified. They're just a random complaint, but it has nothing to do with legal concerns necessarily. So YouTube removes 25% of the content reported. And out of these reported cases, we remove 92% of the cases within 1 day. So every lawyer understands like how complicated this is, and wrong decisions, overblocking, it's just unavoidable. We try hard to look at every single case, but many cases will just slip through the cracks. This is part of the system. And we need to be aware that laws like this have this consequence for freedom of speech. That's just the reality. And then third and last, privacy concerns. I think that this audience is very interested in such concerns. The new proposal to change the NetzDG would apply for approximately 150,000 items for YouTube in Germany from last year. Most of them would be required to report to the police immediately without any oversight, without any specific review of these cases. This is really like a data preservation on steroids, or as some German parties in the opposition are calling it, a suspicion database. This is what we will then need to build. And I think the Constitutional Court and everyone who cares about privacy should be really focused on these aspects.
Thank you, Arnd. Could you just say a couple of words on the Austrian Kommunikationsplattformgesetz?
Yeah, absolutely. So this Communication Platform Act is a very much NetzDG-like law in Austria. It's also targeting platforms, but here not social media providers, but platforms more broadly. It requires a removal of content within 24 hours or 7 days with fine up to 10 million euros. It also differentiates between big and small players. So very, very interesting, like how close it is with the German NetzDG. Remarkable here was the hastiness of the entire legislative process. Because the notification to the European Commission was initiated just in September last year. And then in December, the Austrian government stated that it has received green light from the Commission that this law is in line with European laws. And then without further debate, it was pushed through the parliament just before Christmas and took effect on January 1st this year. So right now we're in a implementation phase for that law until 1st of April. In fact, this Couple G was heavily criticized by the European Commission for not being in compliance with European principles, in particular the country of origin principle. And I think without diving like more into the Kommunikationsplatformgesetz, it's a very interesting trend in Europe to see the French law, the German law, the Austrian law, and actually there are other laws. There's a revenge porn law that is sort of like similar in the approach. The UK discusses the Online Harms Act. Ireland proposed the Online Safety and Media Regulation, and Poland actually introduced an idea of a new law just last week to make sure that content that is legal is not being removed from the platform. So we have all these different proposals in Europe, and that clearly makes it very hard to come up with one joint version of a European law. And as a European, my wish would really be to ask the European Commission to push back a little bit more harder on all these member state laws, because otherwise we will never end up in something that we all want, like a digital single market. And I think we're all up for that.
Well, who knows? We will discuss in a moment if the DSA proposal is the answer to the issue you just raised. But before I go, we start talking about the DSA, one quick question to Suzanne that I forgot to ask. The German Netzdigi only applies to a handful of platforms because only to the very, very big ones. The Austrian Kommunikationsplatform it also only applies to the big or very big players. How about the French law Avia? Was that supposed to also only supposed to apply to the big platforms? Could you just unmute yourself, please?
Yes, great idea. Yes, absolutely. There was a difference. Only the big platforms and search engines were regulated by this proposition, this law, and so it was not for smaller platforms. So yes, there was this distinction, and I just wanted to take maybe a second because we have an audience of data protection experts, and I believe what we're seeing in the content moderation space, they know it well from the right to be forgotten space. So asking platform to judge what content should stay online or not is well known with the difficulties from the right to be forgotten possibility right that was enacted in the GDPR, but was known from before from the Court of Justice, and so I believe this trend we're seeing from law and just Court of Justice rules asking big platforms to do what was before required to be done by a judge or a magistrate is very problematic, and it's a democratic concern we should all have, because I believe it's important to know what are the content we're putting online and what the content should not be online, and who needs to be judge of that is a magistrate with its guarantees of independence and impartiality, and should not be a private company with even if it has good intentions, it doesn't have all the guarantees a judge has. So I believe there is a comparison that can be done between the right to be forgotten and content moderation.
Thank you, Suzanne. And a quick word. Well, we have the three laws that we have been discussing, national laws that only apply to big platforms. Now we have the DSA, uniform rules for the whole of Europe, with 3 tiers of companies, some rules that apply to everybody, some rules that apply to the bigger ones, and some rules that only apply to Google and a couple of other platforms. What is your impression? I mean, it must be great news for Google that Europe is now going to introduce uniform rules so that you don't really have to go into the details of all those national laws. What is your view?
Yeah, absolutely. I mean, you're totally right, Niko, that we really welcome the Commission's intent to fight illegal content online across Europe. We're very much in favor of regulation across Europe. We support this goal of a responsible internet, and we're not supposed to regulation at all. And we hope that we can work very constructively with the Commission, but also with every other stakeholder, with the Parliament and the Council, to make this thing work. And that means to a little bit more clarity on what the DSA really is about and how we make sure that it can still promote innovation, respect fundamental rights, and so on and so forth. And I mean, when you read through the provisions, it's like big and long, it's very heavy, it's extremely complex. But I can see positive aspects already. the maintenance of the core principles of the e-commerce directive is something that we appreciate, including the safe harbors. The prohibition of a general monitoring obligation is extremely important in our mind, and the country of origin principle. And I think it's very good, very positive that the Commission resisted this race to the bottom of who introduces the shortest timeframes for removal, because that's very tempting for politicians, I think, to say, oh, illegal content must be removed very fast, and then it started with a week, and then 24 hours. Now we have 1 hour in France. So I totally understand that illegal content should be removed fast, but it always requires a proper legal assessment, and sometimes such an assessment takes time. So it really increases the quality of the decision when you have more time. But then, of course, Niko, I mean, we have also many concerns about the DSA. So a lot of provisions are not clear yet. I'm not a lobbyist, I'm a company lawyer, and my questions is really like, do I understand what the law requires me to do? Currently, the answer is no for many products. I just don't know. Do I know when I would infringe the obligations and when there's a risk to be sanctioned? No. The grounds for the fines are not very laid out in a specific way. So a lot of clarifications are needed. And then just to stress 2 points that really pop out of the proposal. One is the out-of-court redress. That's an interesting idea, that providers shall engage for all content moderation decisions in out-of-court settlements. It's a super smart idea, but it's not very realistic in our sense, because it requires to start settlements out of court with many millions of complainants and users about the content that's been removed. And these decisions, as the proposal stands right now, are first of all binding, and second of all, the providers are always in the obligation to pay for it. Either they lose, then they pay everything, or they win, and then they pay for their own bills. So this is extremely burdensome, extremely complicated, not very practical. And then the second point is that we and other big platforms are really target of the law. And I understand that politically there's this wish to regulate the bigger players more rigidly. But when you think about it, the risk itself is not provided by big players necessarily, right? I mean, one lesson of the internet is really that small websites can also have a very large reach and can reach a very big audience. So in the same governments, in the same way as governments might apply safety standards to, let's say, a car manufacturer, it's important that the cars are safe when they're on the road. But it doesn't depend if the car manufacturer is big or small, right? So it's not a question of the size of the company, but more a question of how risky is a specific piece of content. But having said that, we're all open to discuss these ideas further, and I think it's a very interesting first proposal.
Thank you very much, Arnd. May I just throw in that I forgot to mention at the beginning of the panel that this panel is sponsored by both Privacy in Germany, which is a great privacy law review that I happen to be the chief editor of, and of Deutscher Anwaltverein, the German Bar Association. And I'm very, very happy that the German Bar Association this year, for the second time, finds this conference so important and finds privacy so important, and all the issues that we're discussing here, that it has decided that this big association with roughly 70,000 lawyers as members in Germany, is co-sponsoring and co-hosting this panel. I should not forget to mention this. And before we now turn to Bojana, and just one remark from my side, just one that I must not forget, and I'm probably we'll get back to that when we were talking with Tiemo, who has meanwhile joined us, the fifth person on the screen, it all reminds me, Arnd, of the GDPR. The GDPR many provisions of the GDPR were meant to target Google and a handful of other big tech companies. So, and the experience has been the big ones can deal. I mean, they don't like very sort of detailed, all these detailed provisions, may make a lot of work and cost a lot of money, but science is just in their DNA, so they can deal with that. And the problems that companies have had with the GDPR have mainly been problems of the smaller companies. So this is something certainly that we should not forget, that if the idea is by the DSA mainly to target the big ones, the experience with the GDPR really points in another direction. And who knows more about the GDPR, and who have I discussed more the GDPR with since really its early beginnings than with Bojana. Bojana is one of the persons that you always say doesn't need an introduction, because everybody knows you, Bojana. But I will still introduce you. You're the president of the Center for Information Policy Leadership, which is part of Hunton Andrews and Court, and you are well, you have been a privacy expert and a light tower in data protection for a very long time, and I'm very, very happy that you're back on a panel with me here, although we all would have preferred to sit in Brussels right now. So, Bojana, can you just, from your GDPR experience and as a privacy expert, what do you think of the draft DSA?
Okay, Niko, thank you so much, and hello everybody. Happy Data Privacy Day, because it is a Data Privacy Day today, and frankly, it's a little bit like a Valentine's Day. Every day should be Data Privacy Day, because we can't forget. You know, I want to have flowers every day, not just in February, but. So really great to be with you here. And kind of the thing that makes me think that is that, yes, I've been doing privacy for so many years, but now I'm doing increasingly data and digital things. I've read the DSA and you know, developed a headache and thinking everything, all these digital D words are just kind of, you know, towering on top of each other, stacking like Lego blocks. It is really getting complicated, getting complex, and we all have to start being proficient in these, what I call ancillary areas of digital. But anyway, it's good to actually remind ourselves a little bit of what we've learned from GDPR. And first thing I would say, and by the way, I'd love to comment later on some of the things you talked about, right to be forgotten, and the expectations as to who decides what content, or you know, how we balance these rights. But first point I would, you know, I think it is welcome to have a unified European level DSA law, just like we wanted to have a single set of data protection rules to govern use of data across the continent or across the EU. And I think that really is important. I do get worried when I see all these countries, you know, mushrooming with their own content moderation laws, just like it was with data protection. It is absolutely essential for these European businesses, for the European startups. If we are going to build a new European Google, and there are lots of European platforms, right? We need these uniform rules. Arnd, you have mentioned the UK Online Harms Act, and we don't have time to go into that. It is similar to DSA, but it's a little bit different because it also talks about the harmful content as opposed to just illegal content. But that act, it's going to be called the Online Safety Bill. It's actually a bill still. It's not passed into the law. We expect it to be passed, sent to Parliament Q2 in this year. But this bill and these proposals they're also extraterritorial. So anybody in the EU, because Brexit, yes, unfortunately has cut us off, you guys, and I'm so sorry for that. But anybody in the EU who is now creating platforms that are accessible by UK citizens will have to comply with online harm bill or online safety bill. And the same is, for all the, US platforms or Chinese platforms who are targeting Europeans as well. So, it is complicated even for Europeans, it's complicated for global. So, my goodness, do we need some kind of, as much as possible, harmonized rules, but of course, knowing that UK will not be harmonized anymore, and not to mention the rest of the world. So that's my first point. Second point is about some of the concepts of GDPR, which I can see in DSA and which I think are very welcome. So the first one is a risk-based approach. Niko, that I've been a huge proponent of risk-based approach in GDPR. And in fact, I'm actually sad to see that we are not making the most of it. So I must say that, because this is a privacy audience. So we need to actually do better, both DPAs and the privacy lawyers and practitioners, to actually make the most of risk-based approach of GDPR, which means you calibrate your rules and compliance based on risks to individuals. That's the idea, right? But at the moment, it seems to be flat. So in DSA, we have got the risk-based approach somewhat, because we have got different rules for different types of intermediaries. And by the way, I think the scope of DSA is huge, right? It is sort of network infrastructure providers, hosting service providers, online platforms, and of course, very large online platforms, over 10%, 45 million, serving over 10% of EU population. So that's a very broad group. But again, just like Arnd has said, I don't think the size matters. What matters is the kind of risk that we create to people because of our services, or risks of misinformation, or risks of abuse, or risks of terrorism, and so on and so forth, and risks that arise on our platform. It could be a very small platform. It could be a new messenger service that is used by drug dealers and terrorists. And, nobody will know about it, but it's a huge risk. So I think there is something more to be said as to how the risk-based approach should work, how we define those risks. And maybe we need some risk impact assessments, just like we have had in GDPR. So organizations must be able to sort of conduct that risk-based approach. And I remember speaking with a group of companies in London when we hosted live a roundtable on children's data. And I remember even then kind of talking about verification of children and so on, and kind of thinking, even there we were proposing risk-based approach. So the more risky the services and impact, the more you have to verify age. But the less risky, perhaps you have to verify less. Okay, that's what it means. So we need that thinking in the DSA as well. And we need that thinking around enforcement. It's really important that enforcement is not done based on technical breaches. That's old-fashioned world. That's not where the world is going. The theory of law and regulation, frankly, we work with Professor Christopher Hodges. It's all about behavioral economics. We need regulators to focus on enforcing DSA and GDPR and all these laws based on risks that are created, as opposed to just technical breaches. Very, very important. Second point about sort of GDPR lessons that I can see translated in the DSA is the notion of accountability. So I like that notion. That we have been pushing under GDPR for organizations to be accountable. We created a framework, simple framework on what accountability means, how you deliver accountability. It goes beyond just legal compliance. And of course, you have to demonstrate that to your leadership internally, externally to regulators, to public, your shareholders, investors as well. And I like this accountability. I see accountability picked up in DSA. I see different requirements for different organizations. I see the need to appoint compliance officer, to have reports, to have redress, complaint handling mechanisms. I think that all is part of it, and being transparent is part of, if you look at Simple Wheel, that's exactly what we say, because it applies in all areas of regulation, not just GDPR. But again, what I don't see is how do you incentivize those who are accountable? How do you perhaps allow those who are accountable to be less impacted by the rules? And you know, as a regulator, do you mitigate also in case of enforcement accountability? Like, those are smart thinking and smart concepts that I would like to see in DSA. And by the way, I want to sort of say kudos. And I've just yesterday saw, and this is to me part of accountability that goes beyond legal accountability, because you don't need to do this. You know, Google has just said that they're appointing or creating a European Transparency Center in Dublin, well, virtual at the moment, right? But and the whole point of this is to actually look as to how Google develops and enforces content moderation, what technologies exist, how this balancing goes, and to be a place where Google engineers, privacy lawyers, policy makers, user design, and of course others, and this is what's so important, others like regulators, like academics, experts, politicians can actually talk about this. We need a debate about what we want to protect as a society, what kind of harm we want to avoid, right? We cannot have, my friends, the position which we had because of the European code, communications code, where now in Europe we somehow cannot monitor children abuse because we think privacy is beyond children's rights. But that can't be right. Like, that debate should have been taken place well before, with the right group of people, as opposed to being caught the last 1 minute to 12 o'clock. That's not to be done. Europe then does not inspire digital confidence in how we deal with these issues. So I like this Transparency Center, because I hope, Arnd, this will provide us an ability to actually debate and discuss these really important things. Okay, my point on relationship with GDPR, I think you have made that clear. It's important that, of course, we respect GDPR, that there is no conflict. Just because the Commission says there mustn't be conflict with GDPR doesn't make it no conflict, right? This is complicated, and the children think has said that. I keep seeing and hearing cases where today Facebook is not allowed, for example, to deploy its suicide watch AI agent because of privacy and GDPR legal basis not being there. Well, I'm sorry, but as a parent, as somebody who has seen what happens, I think actually it's not a bad thing to do, right? So, and it can be done in privacy protective ways. So again, we need accountability helps, because that builds trust, it builds policies and procedures. So we need more of those kind of understanding how these 2 laws or 3 or 5 or 10 laws and all these human rights work together, because that really is important. My last point is the one on enforcement. What have we learned from GDPR? There was a great idea. Apparently, I was at Accenture at that point, leading global privacy, and I remember we had a meeting with Vivian Redding where I said, why do I have to go around 20 regulators at that time and register the same database? This is ridiculous. In the single digital market where there are no barriers to data and people and etc. There shouldn't be. And there was this idea that we can have that one-stop shop, but it hasn't quite materialized. But because it hasn't materialized doesn't mean we must abandon the idea, right? We have to work on it. We have to make it happen from GDPR perspective, but also to serve as a beacon, an example in other area of digital regulation. We cannot have 27, what are they called? They're called digital service coordinators, who will be assigned at member state level. There will be existing regulators, not data privacy, so they'll know nothing about that. It'll be something else. And that will be on top of AI, on top of all the other ones, right? So you can see how our digital regulatory landscape is going to be completely compartmentalized. And so even within a country, let alone within the EU. So we need really to fight for the one-stop shop idea, to make it happen, make it less bureaucratic, and trust each other. Somebody has said we are not trusting each other enough kind of in Europe. A mutual recognition and understanding that if one regulator takes action, that's good enough for the other, That should be the kind of guiding principle. So these are my comments, but very happy to pick up the others during the discussion. Thank you.
Thank you very much, Bojana. Well, as expected, really, when you have such great speakers on the panel, we are running out of time a little bit. I must say already now that there will not be too much time left for the discussion in the end, because well, because of what we've heard so far, and because of Tiemo, who is the last speaker on the panel. Hello, Tiemo. I think most Germans, at least, will have come across your face and your name. Your face and your name, because you're a social media star in the in the tech community. You're very, very active there, setting an example how communication in the 21st century by a politician should be done. We have never had the pleasure of meeting in person so far. I'm very, very happy that we have this opportunity here now. You have been a member of the European Parliament since 2016. Your political life started in a place that everybody in Germany knows, in Buxtehude. Yeah, it's a small place in the north of Germany. And I assume you are now in Osnabrück, is that correct?
Actually, I'm in Brussels today because of the crisis with regards to the manufacturing problems by AstraZeneca. So that's why I'm here at the moment.
This is such a trivial subject that we are not going to talk about it here today. And I'm sure you are happy to talk about digital politics and law. You're a lawyer, I should mention. You have a proper profession besides being a politician as well. And I'm sure you're happy to talk about digital politics today. And so may I now ask you, what are your, if you look at the DSA, it's fresh, it's new. There have been, of course, preparations where there have discussions beforehand. If you look at what is on the table now, I would be interested in what would be sort of your view on what will be very controversial, especially when the European Parliament comes in. What will the European Parliament be critical of, and what would you expect the parts to come through smoothly in the next couple of years? So I'm very curious to hear from you, Tiemo.
Yeah, first of all, thank you very much for the invitation, and I would like to express apologize for being late, and I very much hope for your understanding. But as I'm sure you have noticed, there are, as I mentioned, a few small problems with the vaccine manufacturer at European level. And as I'm also the spokesperson for health issues for the German SPD, there had to be some urgent calls.
It's the Social Democrat Party. I forgot to mention that you're a Social Democrat.
That's true. So the European Parliament had indeed the opportunity to formulate expectations even before the Commission proposed its draft DSA and DMA draft. So I was the rapporteur in charge of the initiative report in the Legal Affairs Committee. And when comparing the Commission's proposal with the recommendations issued in my initiative report, I can say that my expectations were largely met. So let's not forget that when the Parliament started working on the initiative reports, it was still a complete mystery what kind of instruments the Commission would ultimately choose. And if you remember that there would be two proposals, the DSA and the DMA was a very well kept secret for a very long time. So I was very pleased to see that the proposal presented by the Commission in December largely follows the recommendations of my report, with a new dedicated regulation laying down the due diligence obligations for online platforms, including a clearly defined notice and action mechanism for content moderation. So this shows that the Parliament is no longer just processing whatever input comes from the European Commission, but that we take an active part in shaping legislative proposals. So the high degree of alignment between the Parliament reports and the Commission proposal also suggests that the final outcome will be close to the Commission proposal. But, well, you never know what the member states are going to do. So what will be the most controversial issues? There are a few points with potential for controversy, and some points where the Council might take a different position, as I already mentioned. For instance, many comments from the member states about the priorities for the upcoming legislative package concerned the necessity to tackle harmful content, such as hate speech and disinformation, and this already gained more traction after the storm of the Capitol in the United States. But it's very important that we do not mix illegal content and harmful content together and try to address them with the same tools. We have made this very clear in all initiative reports, and we had 3 of them in the European Parliament. And also the Commission has adopted this line. So the notice and action mechanism foreseen in the DSA proposal works for illegal content because it concerns action to be taken when content is clearly illegal. Harmful content, on the other hand, is still legal despite having a damaging effect on our societies. But if the legality of a certain content is unclear, notice and action procedures would do more harm than good, as it would lead to large-scale overblocking. And this was also already mentioned by Google in this conversation. So if we want to tackle harmful content, we must use a different tool. So the question is not so much the deletion of harmful content, but what makes harmful content so dangerous is the fact that it easily goes viral and spreads like a wildfire. So we should therefore look at the reasons why harmful content is so prominently visible to large audiences. And the key factor, and there's a large agreement in the Parliament, are targeted personalized advertisements. So this business model creates the need for personalization of content for individual users and the intrusive surveillance and tracking of their browser behavior. So it also incentivizes algorithms to favor attention-seeking content. And while the Commission and I agree on the analysis of the problem, the Commission's approach slightly differs from the one I suggested in the Parliament and which was carried with a large majority. The Commission mainly wants to facilitate and encourage the development and adherence of code of practice, also on the basis of the Democracy Action Plan. And measures to ensure that harmful content is not monetized are mentioned as an option, but I'm really doubtful as to whether a co-regulatory approach would be sufficient. So if we want to curb the spread of harmful content, we must address the underlying economic factors that make it profitable. This means grabbing the issue by the root and seriously considering whether some forms of online advertising based on behavioral tracking and the personalization of content are really worth the societal damage caused. In either case, the necessity to address illegal content and harmful content with different approaches is the baseline agreement between Parliament and the Commission. And I'm not sure if the Council will share this position, even though the French Minister for Digital Economy has recently also addressed the option of reducing the visibility of such content. Another issue that could become contentious is how effectively the proposal will prevent overblocking. The European Parliament has emphasized in all reports that content moderation mechanisms must safeguard the fundamental rights of users. If the DSA is not to live up to this requirement, we must ensure that the proposal does not lead to overblocking. So this is an aspect on which both the Loi Avia and NetzDG have been criticized. And I think that's right. By imposing strict deadlines and sanctions, platforms are more likely to delete notified content in situations of doubt. it is important that the DSA does not repeat the flaws in the German and French law. So tight deadlines in particular are very critical and pose particular burdens to small and medium enterprises. And we really should keep this in mind as they make up 99% of the European economy. So the Commission proposal is not entirely free of flaws in its context either. According to Article 14, paragraph 3, for example, a platform becomes liable for illegal content upon receipt of a notice and action and must expeditiously quickly remove it, so without any delay. So the validity of a notice hangs on the notifier's understanding of the law and the declaration of good faith. So this discourages platforms from verifying the legality of notified content as they rely on the notifier's assessment. And in my view, this will lead to overblocking of content, and we need to avoid it. And of course, there may be the question of automated ex-ante control for content, the so-called upload filters. We have achieved a position in the Parliament that DSA must not mandate the use of such tools. However, Article 6 of the Commission's proposal allows platforms to carry out voluntary own initiative investigations to detect and remove illegal content. So, in particular, Article 6, paragraph 2 is quite complicated. So, this must be accompanied by fundamental rights safeguards, clearly stating limits and conditions to voluntary measures to ensure they are proportionate. Otherwise, there is a risk that platforms will start employing upload filters, which are absolutely unacceptable. And what aspects will the Parliament be most critical of? To be quicker, the Parliament will make sure that the measures in the legislation are effective yet proportionate. So the protection of fundamental rights is one of the highest priorities for the DSA. We often say that what is illegal offline must be illegal online too, and focus on law enforcement. But the DSA is also about the enforcement of fundamental rights, and we must not forget it. So if we manage to do this, we can develop a distinctly European vision for the internet, which is neither an unhinged marketplace, nor a tool of state power, but the genuine online public sphere governed by laws in which rights of citizens are protected, where people can discuss, debate, trade, explore arts and cultures, and take part in social and economic processes without being disenfranchised, without being exposed to hate speech or censorship. So one last point to the enforcement. I share the concerns on the model chosen by the Commission. I would have liked to see a European entity responsible for this task, because I believe that what we learned from the GDPR is that the system is an idea, but it doesn't work quite well. So if you have an authority which tends to advocate the businesses' interests more than the consumer interests, I think that's not the right way where the development should go to. So, yeah, this would be my take on it.
Thank you, Tiemo. We are running out of time. I'm afraid we just have 4 more minutes. So I think I'll just try to use these 4 minutes, because we will get cut off brutally in the end, we were told. I will just use them to wrap up this panel, if I may. Just a couple of remarks. Thank you very much for all your takes and all your views. And I think we have certainly not managed to walk through the whole proposal of the DSA, but this was not the aim of this panel. Our aim was to just highlight from the experience that we've had with in Germany and France and Austria, and with the GDPR, of course, to highlight some issues that will be certainly will need to be discussed in the next years, and that will certainly accompany us through the next years. If I may highlight one issue that I was talking with this morning when we were sort of talking about how we would do this panel, I was saying when I first read the DSA, it reminded me of the time when I first read the GDPR draft in 2012. And I just remember that I wrote an article, the first article that I wrote about the GDPR draft by the Commission. I'm not quite sure what it was, but the word pyramid was in the title of the, and because there was originally the Commission wanted a pyramid of all the national data protection authorities, and on top of the national data authorities, then the European Board, and on top of the European Board, the Commission itself. And this is exactly the model that we now find in the DSA proposal. Again, I hope that this will not be very popular with the European Parliament, Tiemo, because it, of course, would be a huge self-empowerment of the European Commission in there, and it would add to all the issues that you just raised, Tiemo, with all the the experience with the GDPR and how it works with the 27 DPAs or even more in Germany, and so that it would probably be a good idea to concentrate that on the European level and not to have the Commission to be on top of that, because I mean we're talking about human rights, as you rightly said, and we're talking about freedom of expression, and this should not be the European Commission's job to decide what can be said online and what cannot be said online. I'm being warned that we are just about to be cut off, so all I can do is thank you all on the panel. Thank you, my friends, and thanks to everybody who has been listening here, and I wish all of us and all of you a good further conference. Thank you very much, and see you in Brussels in 2022.
Thank you.
Yeah.
Thanks, everyone.
Thank you.
Thanks for listening.